And the U.S. Supreme Court is now weighing the arguments made today on whether Colorado has a right to ban former President Trump from the 2024 ballot because of his actions on the day of the January 6th assault on the Capitol. Both liberal and conservative justices asked questions that suggested that they were skeptical, very skeptical, of the legality of the move.
For more on this, let's bring in CBS News election law contributor David Becker. He is the executive director for the Center for Election Innovation and Research. David, there you are outside of the Supreme Court. And I encourage everybody to just listen back to these oral arguments. You know, it's how we get insight into how justices look at this case of first impression. What was your impression of what they were focusing in on and the strength of Colorado's case?
Yeah, it was first of all, one of the longest arguments I've ever heard. It was well over 2 hours, and it was one of the most illuminating arguments as well. All 9 justices really engaged, all asked questions of all 3 lawyers, and they didn't focus so much on whether President Trump engaged in insurrection, but they focused on 2 other issues. One, to a lesser degree, they focused on whether the presidency is an office under the United States and whether the president is an officer of the United States. That could be a way of disposing of this case. But they spent most of their time on this key issue of whether states have the power under the 14th Amendment, even if someone did engage in insurrection, to on their own as a state disqualify them from their state's ballot for president, and whether or not Congress would need to act to give them that power. They seem very focused on the issue of whether or not there might be chaos if all of the states could rule differently. If, for instance, the first state to get the case heard, like Colorado here, could essentially decide this for the entire nation when Congress had not acted and given them that power. And I'll have to say, all 9 justices seem to kind of meander around that possible path to resolving this issue, which would resolve this up until the election. But if Trump were to win, it would leave the issue of whether or not Donald Trump engaged in an insurrection to the political class on January 6th in Congress, and we could see this issue come up again.
David, let's talk about the other issue, because we have talked quite a bit about this question of whether there will be a Pandora's box with states being allowed to keep people off of the ballot if the justices rule in favor of Colorado. But let's talk about the other major issue that you outlined, which is this question of office of the presidency, an officer of the United States. I think that for many people who are listening to these arguments, when they first heard Attorney Mitchell, who represents Donald Trump's side, argue that no, the president isn't included because in this case he never took an oath of office because he didn't hold any of those lower offices that most presidents of the United States have taken, and his office or the office of the presidency was not included in the list that's articulated. I think that most people would have thought immediately that that defies comprehension. But then when we heard from Justice Brown Jackson talking about the historical context of this, talk to our audience about reconciling this question and why the office of the president might, in fact, be specifically not an office that would fall under this insurrection provision.
Well, the argument goes that the 14th Amendment requires someone to both be seeking to hold an office under the United States and previously have served as an officer of the United States and taken an oath in support of the Constitution. Those were 2 very separate things. Justice Gorsuch also talked about this, and he really tried to separate those 2 things out and whether the presidency satisfied both conditions. Now, I think there are very good arguments that the presidency does. Some of the justices focused in on the fact that there might be some disagreement there, that the presidency could be an office of the United States, but Donald Trump wouldn't have been an officer of the United States and taken an oath of office. And there was also some questioning from the justices pointing out that that would create this really odd exception for this rare category of candidates like Donald Trump, who had not previously served as an officer of the United States before they ascended to the presidency. Most people, like, for instance, President Biden, have served as an officer of the United States and taken an oath in support of the Constitution. So they focused in on that, but that was probably about 25% of the argument. They really always came back to the state power issue.
All right, David Becker, thank you very much.
Thanks, David.
Thank you, Lana.
We're going to bring back Jessica Levinson. She is, of course, a CBS News legal contributor and a professor for Loyola Law School in California. She's also been following all of this alongside us. Jessica, we're going to try again to play this really salient bite from Justice Samuel Alito, challenging the lawyer representing Colorado earlier about the potential Pandora's box that he felt could be unleashed if, in fact, the justices were to rule in Colorado's favor. So let's play that now.
So I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates. But I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law. Or at the very least, this court could address that when those issues come up, but it seems unlikely.
So, Jessica, Jason Murray's argument seemed to be foundationally that President Trump, an exceptional case in January 6th, and argued for insurrection and therefore was an insurrectionist and so needs to be kept off of the ballot. But the justices weren't interested in engaging or deciding that question today. Do you think that that was a strategic error on his part in trying to convince the justices that they needed to allow Colorado to remove Trump from the ballot?
No, I think it was the best argument that he could make. I mean, he is arguing that the Colorado Supreme Court's decision is a decision that should be upheld, and therefore that Colorado was correct in deciding that Trump is not qualified for the ballot. And I think what you hear in that up and back is something that David mentioned just a few moments ago, that Jan Crawford was mentioning, this fear by all of the justices of, can we possibly allow a single state to make this decision with respect to not a state candidate, but a federal candidate. Lana, I think maybe to the other part of your question, it was interesting to see the justices all kind of back off of this idea of, should we talk about whether or not there actually was an insurrection? Should we talk about whether or not Trump, in fact, gave aid or comfort to those who engaged in insurrection or himself engaged in it? There was some discussion about this idea of whether or not we need to give deference to the factual findings of the Colorado court. Colorado court, of course, did hear evidence. There was something that looks like a trial to most people, where there was a determination that, in fact, there was an insurrection and that Trump's actions involved him enough such that he engaged in the insurrection. And that's why that Colorado court says, yes, Section 3 applied to him with respect to at least those aspects of his actions. Now, I think for the Colorado attorney and for the attorney who's arguing on behalf of those who were challenging Trump's eligibility, this is really, they have to argue this, right? They have to argue that Colorado has the power to disqualify Trump, and they have to argue that Colorado was correct in making those factual findings, that there was an insurrection, that Trump engaged in it, and therefore that he is not eligible for the ballot. Again, what we saw the court focus on today is not those questions, not was there an insurrection, not really did Trump engage in it, but the secondary questions. Does this apply to the presidency? You just had a fascinating conversation with David about officer versus office. And can states do this? Do states have the power under our structure of government to make these disqualification determinations when it comes to Section 3?
And so, Jessica, we've also discussed just the political nature around all of this, that the Supreme Court, according to our Jan Crawford, will want to be unanimous in whatever they decide. They're going to want to keep their decision narrow. They're going to want to kick this back so that they are not in the role of deciding elections, who can and cannot run. But if we spin this forward, if there is a unanimous decision that actually Colorado stepped outside of its bounds in removing Trump from the ballot, what would the legal repercussions be nationwide as other states consider doing the same? especially now hearing how the Supreme Court views such attempts?
So the repercussion is that there's a reason the Supreme Court had to take this case, right? We need an answer because there has been this kind of patchwork where Colorado Supreme Court comes to a conclusion, the Maine Secretary of State comes to the same conclusion, but then other states are saying, maybe I don't have the power to make that determination, or maybe the wrong person is coming to court to challenge Trump's qualifications. If the Supreme Court crafts an opinion that looks kind of what we think it would look like, the idea that the state does not have the power, then what does that mean moving forward, if I understand your question correctly?
Yeah.
And that means that unless Congress acts, that states cannot say that the former president is disqualified from the ballot. And again, I think what we would be looking for is some sort of congressional action. Now, we don't know for sure if that's the way the opinion is written, but what we know is that the U.S. Supreme Court is going to give us the final word on the federal Constitution, and that is something that applies to all states.
And again, I encourage folks to listen back to these oral arguments. It's incredibly revealing of how they come to a decision. Jessica Levinson, we appreciate your insight as well. Thank you very much.